Good evening. This is John Milburn for Laws 11057 Introduction to Law. This is week 10 in term 3, 2016, and we're in 2017 now. So we're getting towards the pointy end, and what we're going to discuss tonight relates to practical application of the things that we've been learning, particularly in relation to research and lateral thinking. Last week we had a session in relation to brainstorming, as I like to describe it, where the task at hand is to think of a number of different options that might be available for consideration by a client faced with a particular circumstance. So for the homework this week, I'd set a number of scenarios, and we'll come back to that. All right, the other thing is that this is feedback week. If you haven't completed your feedback, please do so. It's very important for the university, it's important for me, and it does mean that we can provide a better quality product. So please provide that feedback, and I'm looking to have 50% of the enrolled class at least provide feedback, and at the moment I'm well below that number. So anything you can do to assist in providing that feedback or encouraging others to do, I would be very appreciative. Okay, as a general comment, I have been very happy with the standard of students this term. I'm particularly happy with the presentation of work. As I continue to harp on, it's important that we look the part, and it's important that when you go into second year, you're not going to be bogged down with comments made to the effect that you haven't got the basics right. So if you haven't done so, look again at my sample paper and remember some of those basic details. Paginate your paper. Make sure that you type legislation or case law in italics. When you're referring to a case, type the names of the litigants in italics. You don't type the year or the citation in italics. When you refer to legislation using the word act, capitalise that word, so it's capital ACT. When quoting legislation, don't quote the internet source, but quote the legal citation. Remember that it is the authorised version that the courts primarily look for. Do take care with your grammar. If you have access to the Word program, use the built-in grammar and spelling programs to assist you in that regard. Be innovative, use flowcharts, for example, and we saw some of that in the more recent work that we have seen. And I'm sure that you've all got the idea of footnote referencing. If you haven't, please go to the References tab, which is at the top of the Word program, and simply click on that referencing option. Okay, so thank you very much, and I'm sure that those that have joined us tonight follow all of those guidelines. So I'm really speaking to those people that are watching this session at a later stage. Now, when it comes to the take-home examination, you will be required to consider a different way of thinking along the lines of what we've been doing this week and last week. That is, rather than ask you a traditional legal question in essay style, you'll be given a problem, and your task is to provide a number of alternatives for consideration for the potential client. We'll talk more about that next week, and that'll be the main focus of next week's tutorial. But when you think laterally, you need to think about a whole range of options and not just the litigation option. So at an extreme, an exam paper in a law subject could be a simple essay question, and it might be something like, explain the difference between common law and equity, or common law and legislation. So some sort of essay style question. It won't be that. It'll be presented with a problem, and you need to come up with creative ways to consider solutions for that problem. Okay, one of those is mediation. We talked about that last week, and it is important that you in a mediation session, create a connection with the participants. Professor Ashman from QCAT explained it this way: make the participants feel as though you're their new best friend. Obviously, that's not the case, but as a mediator, that's your role. So you need to be a person that they will respond to in a positive way with a view to coming to a resolution of the matter. So a good mediator is quite dynamic and quite lively and quite approachable, and uses a whole range of techniques for assisting the parties to resolve their dispute. Now, I'm not saying that the mediator is loud or eccentric or anything like that, but what I am saying is that there are certain techniques that we use. So if you're interested at some stage in your course, please consider Laws 12062, Alternative Dispute Resolution, and that's a course that I've taken over the last few years, and we'll talk more about those sorts of issues in that course if you go down that track. But for the sake of introduction to law, mediation is important because it is probably the most important alternative to litigation. So it needs to be something that you consider, and you need to be aware of some of the techniques that mediators use, because if someone is faced with a problem and you suggest mediation, it's important that you understand what mediation is about, and that means having some basic understanding of what a mediator does. Now, do we have any mediators joining us tonight? Has anyone been involved in a mediation? Do you know the system? No, looks like no. Okay. So mediation is, I'll just very briefly give you a rundown. A mediation session for a simple matter might take 3 hours or 4 hours. The mediator will greet the parties, go through a spiel, if you like, outlining what the mediation process is all about, then invite the parties to identify their side of the story. In turn, no interruptions at that stage, and following that introductory statement made by the mediator and then both parties, typically the mediator will construct an agenda, and that agenda may have 3 or 4 items on it typically, and we try to restrict the agenda items to a word or a phrase, and we work around those issues and those problems. So we try to be quite creative. We try to have some form and substance to the mediation. Once we do that, we then have an open session where there's open dialogue. Quite often parties are very emotional at that stage. A good mediator has techniques in terms of how to bring the parties back to the issues and take them away from their positions, if that makes any sense, so that we're trying to identify and work on the issues, the problems that we might have. And what a mediator will do is be lively, will be creative, and you have to think on your feet. To borrow what District Court Judge Kingham, formerly the Deputy President of QCAT, says of it, you need to be light on your feet as a mediator. Listen for a word that may provide an opportunity for future discussions between the parties, and then encourage the parties to come to a resolution. A very important aspect of mediation as opposed to litigation is this: that in mediation you are acknowledging that it's the parties' dispute, and you're encouraging the parties to talk directly to each other in relation to that dispute. Whereas in litigation, the dispute to some degree is taken away from the parties and put into the hands of the lawyers. And that may be a good thing, but very often it's not. So, in a mediation session, if things are going quite well and people are starting to talk to each other, they will talk to each other naturally. They'll talk about the witnesses in a natural manner. They'll talk about the circumstances in a conversational way. Even the language of litigation is different. Suddenly, Bill Smith becomes the plaintiff and Mary Jones becomes the defendant, and we talk about the plaintiff and the defendant. as if they're not there. So that's why I say that mediation is an opportunity for the parties to take ownership of the dispute and try to come to a resolution of the dispute themselves, as opposed to the lawyers taking control of the process, speaking a different language, a language that the clients may not necessarily follow or understand, and then a decision is imposed upon them by a judge or magistrate or judicial officer or presiding officer in circumstances where in a mediation the parties retain control of the dispute and they can be very creative in the way in which the dispute might be resolved. All right, so that's just a brief overview of the mediation process and why it's different to litigation. And the reason I'm talking about that now is that when you come to resolve an issue for a client, they're not likely to come to you and say, here's the nature of my dispute, here are the parties involved in the dispute, here are the issues that are of concern, and I have a distinct preference for mediation first and litigation second. Can you act on those instructions? It'd be nice to think that clients could package it all nicely like that, but it just doesn't happen. So what will happen is that clients will provide you with lots of information, and your role is to, amongst other things, identify the material facts, identify the players, consider the personal circumstances of the client, the other side, think about all those brainstorming issues that we talked about last week, and then start to provide some options for the client to consider. And that may be mediation, it may be litigation, it may be other things. Okay, so that's what we're talking about. All of that can be done within the context of the IRAC method or the MIRAT method or whatever acronym you choose for looking at legal logical thinking. I hope that makes sense, and I know I'm moving fairly quickly. All right, but if we do have litigation, then we need to understand the research steps, in the research skills involved in litigation. And there are some preliminary questions that we need to ask as well when we're looking at a factual scenario. So now I'd like to think about how we make the first concrete steps when presented with a legal problem. And this is something that we'll need to consider for the take-home exam. Okay, so let's assume for a moment that someone's presented you with a debt problem. What are some of the first questions that you might ask? And you can unmute your microphone or use the chat facility. So just in general terms, someone says, I want to chase a debt. What are the things that go through your mind as a lawyer? All right, so what's the debt for? Okay, thanks, Shireen. What else? What questions would we ask in that first stage? How much is the debt? Thank you, Shireen. So what's the debt? How was it incurred? And how much is it? What else are we going to ask? What parties are involved? Thank you, Simon. That might be relevant and may not be so obvious. It might be a company involved or a trust involved. So you need to identify, there's no point going and suing someone only to find that you've sued the wrong party. That can be a very nasty consequence. All right, so how much is the debt? How was it incurred? What parties were involved? We can think of another few. Alan?
I think the question of what would it take to resolve the debt, to remove it.
Okay, so we're looking at a solution there. Thank you. But for the preliminary questions, Simon says, what legal avenues can be undertaken? In other words, is it a small claims court or maybe through a subcontractor's charge? So we have to think about the debt recovery methodology and place that we go. Says Simon. Alan says we think about What's involved in trying to resolve it? Have they tried to retrieve it? Says Shireen. Yeah, that's a good idea. What steps have you taken already? What else are we going to ask? Think about what might go wrong if you don't ask the right question and you get into court and you get a nasty surprise. How about when was the debt incurred? Partly because you need to put that in your pleadings, but also to ascertain that it's not statute barred. No point chasing a debt if a limitation of actions precludes you from doing so. Shireen says, have they tried to retrieve it? Is it in Australia? Yep. If it's a debt outside the jurisdiction, that's relevant as well. Okay, so is there any documentation? If so, where is that documentation? Was it signed? If the debt was for a product and you're acting for the seller, you might ask, well, did they order the product? Did the defendant order the product? Did the defendant receive the product? Did the defendant agree to the price? So Shireen says, were there any agreements? Did the defendant acknowledge receipt of the product? Was the product in good order? Were there any defects associated with the product? Does the defendant have any money? Is it worth chasing? Is the defendant related to you? Is it your family? Is it something that you want to chase through litigation, or do we look at other means, which comes back to Alan's point? So there's a whole, and then to take up on Simon's point, once we've decided that it's worth pursuing and we discount for the moment mediation and we decide to pursue the debt, you've then got the whole thing about, and Ernest says, when was the debt incurred? Then you've got the whole thing of, well, which court or tribunal or jurisdiction or methodology do we use? Simon had said, well, I think it was Simon said, how about a subcontractor's charge, which is a way of taking security over the debt. I mean, if the debt is already secured by way of a mortgage or bill of sale, then you might consider that option of trying to enforce the security instead of necessarily suing for the debt. Last week, we talked about a statutory demand, which is a demand made of a company immediately, not necessarily with suing, to say, unless you pay this debt, then you will be deemed to be insolvent. So that can be a very aggressive way of trying to pursue a debt. Okay, so there's a whole lot of things that you might consider. And a few weeks ago, I think we talked about the jurisdictional limits of different courts. So you need to know, if you're chasing a debt for a certain amount, which court or tribunal do you go? Okay, so having done all those preliminary things, then we might need to think about the cause of action. Now, I mentioned something just a moment ago called pleadings. Does anyone know what pleadings is all about? What's a pleading? Okay, so when you go to court to pursue a debt, for example, the way to do it is to complete the forms, the court forms. Now, the forms that you use and the degree of formality that is incorporated into those forms depends on the jurisdiction. So some jurisdictions in the small claims or the small minor debts division of QCAT, it's quite informal. But if you're going in the Supreme Court or the Federal Court, it's quite formal. And so, for example, in the Magistrates Court, the District Court, the Supreme Court, you need to file a claim and a statement of claim. And they're part of the pleadings. So the statement of claim is a very important pleading in that you, as the lawyer, draft the pleading, which identifies the material facts. In that document, you don't put your evidence, you don't say, this is how I'm going to prove it, and you don't state conclusions of law, but essentially you plead the material facts. So it might be something like, at all material times, the plaintiff was the supplier of goods, the defendant was a customer of the plaintiff. On such and such date, the defendant sent an order request to the plaintiff with a request to be, for certain goods. On such and such date, the plaintiff supplied the goods to the defendant. On such and such date, the plaintiff issued an invoice to the defendant. Despite demand, the defendant has failed to pay the amount of the debt, and the plaintiff claims the debt, the plaintiff claims legal costs, and the plaintiff claims interest. So that's the pleading. So in the statement of claim, we're just putting the material facts. Now, you notice in that I didn't say the evidence. I mean, I've put some of the material facts, but, I'm not going to put in there something like on the 10th of, November, one of the plaintiff's directors went out to the defendant's residence and they had a chat about the product, et cetera, et cetera. So you don't go into too much detail in the pleading. That's a very simple explanation of pleadings, but you get the idea. It's the material facts. And that's one of the reasons why when we're doing our interview with clients and we're looking at a legal situation, I always want you to think about what are the material facts. What makes a material fact in the context of a pleading? Does anyone tell me that? It's an obscure question. You're very quiet tonight, so I'm trying to encourage you to talk or tell me on the chat facility. What makes a fact material in the context of a pleading? Yes, Grace?
Do you need a witness or a recording or something?
Maybe. That's more to the evidence that you adduce to prove the material fact. Yes, Alan?
I think relevance is, if it's not relevant, then it's not material.
Yep. I think that's a really good thing. So it's got to be relevant. If it's not relevant, if you don't need it, then don't put it into the pleading. It's not material. And I think if you're looking at a contract, you might say, well, in order to win this case, these are the things that I need to prove. I need to prove there was an order, there was a delivery, there was a claim for payment, there was no payment despite the claim. If I can prove those things, then I win. So whatever I need to put in the pleading that goes to show those things, well, that's material. If it doesn't really prove that, it's not relevant, it's not in the pleadings, it's not material. We might put it in an affidavit, or it might go in as part of the oral evidence, but it doesn't go into the pleadings. Okay, so thank you very much for that. All right, so when we decide to sue someone, we have to think about the cause of action. So it might be that we're suing for a breach of contract, or it might be that we're suing for failure to comply with the Australian consumer law. And it may be that we need to think about taking some action before we actually sue, and that would typically be in the form of a letter of demand. So even before we've actually sued, maybe a letter of demand. Now, can anyone tell me why we should send a letter of demand before we sue for a debt, typically? Any reasons? Alan?
It would set the parameters of what is being demanded and what might ultimately be argued in court.
Yep, that's a very good reason. Any other reasons why you might send a letter of demand?
Maybe to give them an opportunity to pay before it came before the courts.
Absolutely. And that can have a bearing on the issue of costs. So once you've sued, people are incurring costs. Your client is incurring costs. You want to claim those costs from the other side. If you don't send a letter of demand, then the court may say, well, yes, the amount is owed, but you should have given them a chance with a formal letter. So we're not going to give you your legal costs. Okay. What you should always do at the start is try and obtain
We can't hear you, John.
Sorry, Sharon. Thank you. What you should do is make sure that you take a formal statement from the client, and you should take formal instructions from the client and consider those various alternatives that we've talked about. Okay, there's the jurisdictional issue and there's the costs. Now, there may be some preliminary steps which are required by law before you sue. Can anyone give me an example of a preliminary step that would be mandatory? Well, one, for example, is that before a lawyer can sue for outstanding fees, the lawyer is required to provide an itemised bill. So just there may be some legislative or procedural requirements that you need to be aware of as well. Okay. Now, I mentioned that when you're suing for a debt, normally you would sue, you would make a claim for that, supported by a statement of claim. There is another type of initiating proceeding. It's called an application, and that would normally be for circumstances where it's a question of law that is being pursued. But for a debt, normally it would be a claim. The response to that, if it's going to be contested, would be a defence and maybe even a counterclaim, and then there would be the possibility of a reply or a defence to the counterclaim. So that's the completion of the proceedings side of things. Okay. Now, when you're considering the options for a client, sometimes you need to consider urgency. So urgency means that there may be good reason not to go through the usual litigation process, which can be quite time-consuming, and you do something with immediate effect or intended immediate effect. Can you give me an example of why you might need that, and what would you be claiming in court to do something immediately? That is, to get an order of the court with immediate effect. Example? Yes, Alan?
There might be some urgent circumstances that the client's facing, possibly family disruption or something social, and that could provide a justification for an urgent resolution of the matter.
Okay. Yep. So there may be some reason for the urgency. What if you get word that the defendant is about to leave the jurisdiction and take assets with him or her? Perhaps that would give you grounds for urgency. Okay, opponent may be closing up business, says Ernest. Yes? All right, so what type of order would you seek if you want the court to make an order that has an effect on the other side immediately?
Is that some sort of stay or order to cease and desist of some kind?
Yes, yes. So in a domestic type situation, it might be some sort of restraint. But what's the word that I'm looking for? And I'll give you a hint. It starts with I. Simon says injunction. Thank you. That's it. So an injunction is an order of the court which has the effect of stopping someone from doing something, or has the effect of compelling someone to do something, which is a mandatory injunction to force them to do something. So an injunction is something that can be obtained from a court at short notice, and sometimes, if the circumstances warrant making such an application, the application for the injunction can be made on what we call an ex parte basis. What do we mean by ex parte? No takers?
With respect to?
Not quite. Not quite. Without representation in court, says Ernest, not quite. It means essentially without the other side. Sorry, Shireen, we were about to say that?
Yeah.
Okay.
Yeah, I think I was something like that. Yeah.
All right. So sometimes if, for example, you hear that someone is trying to remove assets, evidence is about to disappear, there's some good reason, you can apply to the court for an injunction without telling the other side. So we'd call that an ex parte application. So when you're speaking to your client from the outset, you've got all these things going through your mind. The client's not going to package it very neatly. It's not likely that the client will come in and say, here's my legal issue, here's what the other side is doing. I believe that we need to obtain an injunction ex parte in the federal court. That's your job, to take all that in and come back with some solutions. It may be that the solution is one where we can proceed at a relaxed, ordinary pace, or it may be that there is some urgency that would require you to consider an injunction. Now, the type of order that you seek will generally be a legal order or an equitable order, or it can be a combination of both. What on earth do I mean by an equitable order? And can someone give me an example of an equitable order? Remember early on in the course we talked about the development of the law of equity as opposed to the common law, and the common law was the black letter law, very strict, whereas equity was involved in providing a response or an outcome that was fair. Some of the equitable principles still apply. So there's all those equitable maxims that you would have read about. And some of the equitable remedies are still available. So one of those equitable remedies is an injunction. Equity says it's only fair that we stop someone from doing something immediately. So that's what we call an equitable remedy. It's an example of an equitable remedy. Another example of an equitable remedy is specific performance, which is in itself a form of an injunction. Specific performance is an order of the court specifically ordering someone to do something. Now that's, for example, very useful in real estate. So if you're acting for the buyer of real estate and the seller for no good reason refuses to settle, your client may provide you with instructions to say, I really want to buy this real estate. You may say, well, we could sue for damages, or we could sue for specific performance, which is an order of the court compelling the seller to proceed. And if the seller doesn't proceed, then the registrar of titles is legally authorised to sign on behalf of the seller as part of the order. So we call that specific performance. It's an equitable remedy. So if we're going to do our take-home exam well, we need to think about how do we identify the material facts in a scenario? What are the options available to the client in a general sense? What are the litigation options that are available to the client? Where do we go to seek the order that we need? And what type of remedy do we ask for? Do we ask for a legal remedy, such as damages, or do we ask for an equitable remedy, such as injunction or specific performance, or do we do a combination of both? Do we seek and obtain an injunction first and then pursue the damages claim later? Maybe we do. And if we do claim something like an injunction, are there any strings attached? So we need to think about those issues. Just for an injunction, when I say a string attached, I don't really mean it's terrible, but as you might expect, if you go to a judge and say, look, I need an injunction, I've got good grounds to do it, we have to assume that there's a possibility that your case is not well founded and the other side, if the court stops the other side from doing something lawfully, the other side may incur a terrible loss. So it may not come as a surprise to you that when you seek an injunction of a court, it's quite usual for you to have to provide some sort of undertaking as to the damages that may be caused if the injunction proceeds and it's not well founded. So that's what I mean by a string attached or a consequence. Okay, I've been doing a lot of talking. Am I going too fast or are we following? All good? Okay. All right, so there may be some other issues, credit ratings in a tenancy situation may be relevant as well. Don't forget that there may be statutory or other bodies that you can rely upon to assist you in terms of providing some benefit. Then, of course, there may be the issue of trying to recover the money. Once you've succeeded in obtaining an order of the court or the tribunal, you then have to think about, all right, what do I do with this? Because the other party may simply say, well, I'm not paying anyway. You might have an order of the court. Can anyone tell me what you might do with an order if the other side, the defendant, refuses to comply with the terms? Any thoughts? So you have an order, the defendant... is
something about contravening?
Contravening, yep. Contravention orders, particularly in the family court jurisdiction or the federal circuit court jurisdiction, often apply. Yep. So contravention. So apply to the court for a court order. Breach, says Shireen. So let's say you've got a debt, and the debt order is for a certain amount, $50,000. The other side refused to pay. What can you do with that? Well, has anyone heard? Yes, Sharon?
Can you send in like a collection agency and they can recover an asset in place of the amount?
Okay, yes. So that might be possible. The order itself doesn't enable you to immediately walk in and take things. You need to go to a further step. You need to obtain some sort of warrant in order to do so. Or it may be that if money is owed to the defendant, you can garnishee the payment that's owed to that defendant. We see that with wages quite often. So what's a garnishee?
It's a compulsory amount that the government is entitled to take out of someone's pay.
Yes.
If they have to pay child support. Or...
That's it. And not necessarily just the government. It might be that your client is able to apply to the court for a garnishee order. Now, all of this happens after you've established the debt and you've obtained an order that the defendant must pay $50,000. If the defendant refuses to pay, then you must take further debt recovery action, and that might be to obtain some property through a warrant, or it may be to garnishee a payment that's due to that person. So your client won't be terribly impressed if, having done all this, you tell them as you go, well, we'll need another $6,000 now to pursue this avenue. The client might say, look, I wish right at the start you'd said to me that there was a risk that I wouldn't get paid, or if I didn't get paid, I'd have to go and do all these other steps. So the client may say, gosh, I wish I'd known about these things. So that's what I mean by taking this sort of holistic view from the outset to say to the client, these are the sorts of things that you need to consider. All right, any questions or comments about what we've discussed so far? All right, what I'd like to do now is just look at the specific detail for the homework and think about those things we've talked about tonight in the context of specific problems. Okay, so here we have the first scenario. Your client says, I want you to initiate proceedings. I would like you to consider the appropriate court or tribunal where you believe it's appropriate. Okay, so we're not talking mediation, we're not talking subcontractors' charges or statutory demands. We're now talking about straight debt recovery. A client wants you to pursue a debt for $5,000. Where do you go? What's the appropriate court or tribunal? Yes, Sharon?
QCAT. QCAT.
Yep. Anything else? You could go in the magistrate's court as, yes, sorry, Sharon.
Oh no, you're right.
You could go in the magistrate's court as well. And QCAT, you may be able to go in the minor civil disputes, minor debts action, or you may be able to claim it in another manner. So the important point that I want you to take from that is to have a look at maybe some courts or tribunal websites and get a feel for where you might take certain actions and what's involved in that process. All right, what if your client says, I want you to pursue a debt of $50,000? What court or tribunal is appropriate?
Magistrates court.
Okay. Can you go in the district court? You probably can, but you shouldn't. Because even if you're successful, the court will not be impressed. They'll probably transfer it to the magistrate's court. There'll be a whole lot of costs associated with it, and even if you were successful, they'd only pay you on the magistrate's court scale. So probably a debt $50,000 in the magistrate's court. But what about the nature of the debt? What if it's a domestic building dispute for $50,000? Where would you go with that?
You'd start with the magistrate's court and it may go elsewhere.
That's an option, although it's best if you go to the most appropriate court or tribunal from the outset. If it's a domestic building dispute for $50,000 or even $500,000, you'd probably go to QCAT. So what I'd suggest that you do is have a look at the jurisdictional ambit of QCAT. It's what we call it, one of the super tribunals, created in 2009. It was an amalgam of, 30 different tribunals, all to become QCAT, and it's something which is now throughout Australia, practically speaking. So if that's the appropriate jurisdiction, that's where you should go. Otherwise, if you go to the magistrate's court, which you probably could do, Alan, you run the risk of wasting some legal costs and time, and clients don't like that. So the important message for tonight is think about the amount of money and think about the nature of the claim and have a good idea as to where different types of claims should go. Also think about other options that might be available. Right, so if your client wants to sue as a result of a faulty refrigerator worth $2,000, where do you go?
QCAT or the magistrates court.
Yep. Ernest says fair trading, which is a good avenue, but it's not litigation as such. But that's always a good option as well. Okay, and if it's a faulty motor vehicle, probably QCAT or magistrates court. Anti-discrimination, there are a few different avenues there. So for the take-home exam, just assume that you'll be faced with a situation where you have to make some of these recommendations. So it's important that you have a good understanding of where you should pursue matters and how you should pursue matters. All right. Thank you. You've been very patient tonight. Are there any, on a public holiday as well? Are there any
John,
questions?
there's actually there's a good thing on the Queensland Law Society that spells it all out. I'll put it on you, crew.
Excellent. Thank you, Sharon. That's great. All right. Excellent. That would be a wonderful resource. Okay. Any other questions, comments? All good? Okay. Well, I'll stop this recording now. For those of you that will join me in statutory interpretation, we'll see you in just over 10 minutes, but I'll end the session now for Introduction to Law. Thank you.